do that. And I'm sure you'll get a little pop-up on your screen letting you know about that. And then for the next minute or two, I'm going to divide my attention between our content and people still needing to be admitted. So if I seem more distracted than usual, how would you know? Um, we'll get that rolling in a second. Let me see if I can do. All right. Can you see my rad PowerPoint?
Yeah.
Yeah, I know it's pretty impressive. Um, okay, so I'm going to tell you what I have on my to-do list, and then I think we can blow through that in as little as, a couple minutes per topic, or we can spend as much time as you want on any one part of it. And then I want to leave room for you guys to just ask the questions you have. So, ta-da! Freddie, the very first thing is star pages and pin sites.
Right.
Because you know what? It's not self-explanatory. It's not readily apparent from looking at these opinions how you're supposed to know which page you're on or which reporter you're supposed to use. So it's a 100% legitimate question. So good job. Um, so we're going to start with that. And then I want to just revisit kind of conceptually the kind of purpose and structure of the counter analysis or a counter argument. And then I thought we could look specifically at Stewart since he's still on our minds and in our hearts. And then, and because we're pivoting away to a new client. And so I think we have one more assignment with Stewart, but not with the content of Stewart. So I wanted to really look at the counter analysis there as kind of as a practical matter. What can it look like, and why did some of the feedback look the way it looked? Why was it so gosh darn hard to do that assignment? And why could you not tell whether you'd nailed it or not? So those are my goals, but I don't want that to take up the hour. What I want to do is make sure that if you guys have questions, you get to ask them. And so make yourself a note, and if I don't touch on them blowing through this, then we'll come back and we'll talk about it in more detail if that sounds okay. Okay. All right. So to start off, I realized from looking at your submissions on our kind of policy um, analysis assignment that, of course, this is ridiculous in like another language. I don't know how much you covered about reporters, pagination, that sort of thing. Whoops, that was a sneak preview in your legal research class. Have you talked yet about where, how to identify which page you're on and which reporter you're looking in? Okay, so I'm going to give this as a refresher, and then and I want to show you a couple different things to bear in mind. Okay, so when we read People v. Aguayo, when we look at it on Westlaw, we get this information just in the caption, for Pete's sake. It's chock full. Number one, we could download the original image PDF, which actually is the scanned pages from one of the published versions of this case. So they're in the olden days, we used to look at these big honking books and opinions were bound together in order, right? One reporter is this P, the Pacific. Then there's the Cal reporter. And there's also down here, Cal Fifth, right? And that's where only California Supreme Court opinions are published. So we've got three different books minimum that this little opinion alone has been published in. So we've got three books, meaning three different sets of pages. It appears at a different place in each of those books. And that's what our reporter information tells us. So it's a Supreme Court case. It was published in the Cal Reporter, fifth edition, the 13th volume of the Cal Fifth, and it starts on page 974. Does that, here, let me turn on my little dorky little laser pointer. Okay, it starts on page 94. If we're looking at it in the Cal Reporter, right? If we're looking at it in the Pacific Reporter, in that volume, and this matters because, well, why does it matter? You tell me. Do you guys know why it matters?
The page numbers will be different.
The page numbers will be different. And how do you pick which reporter you're going to cite to?
The The official reporter of the California Supreme Court would be the Cal reporter.
That's right.
And the other
So
one,
it's going to depend on the court you're practicing in. So in California courts, your rules, and if you look at the California Style Manual, you're gonna cite to the Cal reporter, probably, depending on. There's also then, if you're in federal court, we love our regional reporters, the Pacific reporters. You're gonna cite to the P site, the Pacific reporter site, if you're in federal court. Oh, fun, right? And then it could be that whichever judge you happen to be appearing in front of, or whichever court you're in front of, if you're practicing in, I don't know, Santa Barbara, they may have local rules that tell you which reporter they like. So the fun will continue, but that's why it matters that you know which one you need to use. Okay, so we've got our Cal reporter, and then we've got the 515th volume of the third edition of the Pacific Reporter that starts on page 63. We got the Cal Reporter, which is where all the published Court of Appeal decisions from California and California Supreme Court opinions are published there in the Cal Reporter. 297 is our volume, starts on 327. At least those three. I don't know. I have not had an opportunity, see how I made that a positive, to use the daily opinion service. That's where the slip opinions before they actually go into a book. And so that's not but we got a minimum of three, our Cal Reporter, our Pacific Reporter, and our Cal Reporter. How do we feel? Are we good with that so far? Okay. So and then Westlaw Blessings gives us this PDF we could print out. If we were practicing in federal court, that would be rad because it would actually look like it's the actual pages out of the Pacific Reporter. So it has that pagination. When you look in the corner of that document, I think I opened it up. Let me grab it for you. When you open that up on your screen, I'm trying to see if I can drag this. Sorry. Close. Not quite. When you open it up on your screen, ta-da! You can see what it actually looks like, where it starts on, right? We're in the Pacific Reporter. It's volume 515, and the very first page is on page 63. So as we're reading this, when I go to the next page, I could comfortably say it's on 64. Why are we not going to cite to anything on page 64? It's a pop quiz.
Those are all keynotes from what?
Yes, they're all head notes. And so that's not part of the court's opinion. We haven't even started the opinion, but you'll notice that our citation starts where we've got the beginning. I'm going to squinch this down so you can see there. Our citation starts on page 63. So we cite to 515 P third 63 because it starts on 63. None of this is citable. This is the synopsis, remember, written by the publishers, not written by the court. Then we've got our head notes. Oh, a whole bunch. Oh, here we are, way down at the very bottom corner. It starts to tell us the court information. It tells us the lawyer and the party information. And then finally, here on page 65, the opinion starts. Blessings. There it is. Okay, takes long enough. Now, if I go, oh, factual background, okay, that's probably not where the policy stuff is. Oh, discussion. Different statements in this. This looks promising. So here I am. Now I know I'm on 66. This is easy if this is what I'm working with. How often are you going to have this? Very small percentage of the time, unless you go sit in the law library and pull the reporters off and stack them on your desk while you work. But most of the time, you're going to be working from Westlaw or some other online source. So let me see where I've hidden. Here we go. Okay, here's our online version. Here, whoopsie doodle. Sorry, guys. It's got too many windows open. Give me one sec. Let's go back to our friend. There we go. Okay, is Agaio up there for us? Okay, so most of the time we're working from this, and we have way up here at the top, People via Gaio up at the top left, the name, the court, the date, and look at all these, we call them parallel sites. There's our, the Cal, the P Third, and the Cal Reporter. Now, when I'm reading this, assuming we know, oh, okay, we're going to be in federal court. So I'm going to be citing to the Pacific Reporter. I would start using that in my note taking from the beginning, just as a practical matter. I would start referencing those pages as I make notes for myself and reference back how I'm going to find what I want to use. Or if I know I'm in a state court and they're going to ask me to cite Cal for Supreme Court opinions, then I know that, or Cal Reporter. I'm going to use those pages. But where are they, Catherine? Thank you for all that chatting. Well, same thing. Synopsis, not part of the opinion, blah, blah, blah. None of this. It's all written by the publishers. Here we go. We're coming down. Lordy mercy, there's a lot of them. Oops, attorneys and law firms. Groovy, groovy opinion. Ta-da! Now we're actually in the meat of this thing. And what these pages called star pages, those are your actual pin sites. That's where, I'm going to see if, oh, mercy. No, let's not do that.
Professor, someone got kicked out and said they're in the waiting room.
Oh, all right. Hold on. Thank you for letting me know. Got kicked out seems harsh. Okay.
Yeah.
We should all be back in. Okay. So here we are. We finally got down to where the opinion starts, and these are our star pages. And here's a little hot little tip. So 2 stars, right? 2 asterisks are where this is the start of page 65 in which reporter? Pacific. Right? When we looked at that PDF of the actual Pacific Reporter page, we saw that the opinion itself started on page 65, right? So that's what this is telling. Hey, if you're in the Pacific Reporter, you're starting, you're now on page 65. So if you're going to talk about anything here, if you're going to use any of the material here from this 65 star page all the way down until we hit 66, here's 66 down here. Do you see that under factual and procedural? Okay, all of this is on the physical page 65 in the Pacific Reporter. Oh, but Professor Lohmeyer, what are these other numbers? Well, all right, the 1 asterisk, right? 979, dun, dun, dun. That is the actual pin site, the star page for the first in our parallel sites, our 13 Cal 5th, 974. On 979 in that reporter, 5 pages later, after 5 pages of head notes and whatnot, finally on 979, the language of the opinion starts. And then all the way throughout, where there's a single asterisk, that's our pagination for this Cal 5th reporter. Feel believable? And where we see the double 2 asterisks, that's our pagination for our Pacific Reporter. And last but not least, our 3 asterisks are the starts of the pages in our Cal Reporter, which started on 327. So as you're reading along and you think, oh my gosh, right, I'm going to blow this partner or court's mind with my gripping discussion of something, legislative intent. There's what I'm going to talk. I'm going to use some extrinsic evidence and talk about the legislative history. And I'm going to use this super cool information from Aguilar, where an assault on the person of another, blah, blah, blah. I'm going to know that if I'm what report am I in? If I'm using the Cal 5th, then I need to figure out, I'm on page 986. It started right above the stuff I'm going to use, the material I'm going to use. If I am in the Pacific Reporter, what page am I on right here? What page of that Pacific Reporter? Is it super hard to see on your little screens?
69?
Yes, exactly, because page 70 doesn't start till right there below what I highlighted, right? Nice. Okay, and we're going to wander around here and see if we can find where we are in the Cal Reporter 336. So up there is 335. And if we scrolled up, there's the 335. So that's where we are. That's That's it. And when we actually start citing things, using Blue Book in another week, in week 7, this will matter a lot. So knowing how to find these will be important. It's important for you now because if you are starting case notes and charts and things like that for the new client that starts in week 6, um, it'll be so much easier if you don't have to scroll through these things every time and re-find it. If you make yourself little informal notes about which page you found the information on, all the better. Okay. Any questions on those? Okay, good. Alrighty. So back to our, I think we're through that. Okay, content and structure of the counter analysis. I really want to get rid of our, can I make you go away? There we go. So nothing super easy about it. But I think for me, may not be for you guys, but for me, the most important thing with the counter analysis conceptually, because I think it's easy to get your feet tangled up while you're trying to do it, is start by orienting yourself. What did I just say the winning argument is? What did I just say is going to be the outcome, right? I either said in Stewart's case, it's going to be a burglary tool or it's not. I'm going to either say it was assault with a deadly weapon or I'm going to say it's not. Whatever I concluded conceptually now, for purposes of explaining my counter analysis, I need to think about, okay, it's likely the opposite of what I think the outcome is going to be, or it's some variation on that theme. It's a slightly different version of it. It might be, if it's a sentencing issue, it's going to be, well, I think there is an argument for a downward adjustment, right? We might be able to present something that would bring it down a little bit. It's not necessarily, but it's something other than the definitive conclusion we are predicting is most likely. So orienting yourself with that, you're going to think, I have to tell my reader, explain what the law is out there that makes me think there's this other potential approach to this problem. And once I've done that, I need to explain the law, but then I also have to explain, meaning analyze. I have to apply this alternative view to the facts of my case. And then I have to tell my reader why this is not likely to be the prevailing argument, right? So I just said it is a burglar's tool. However, there's this notion in this case law that it's less likely to be a first-degree burglary if the burglar's tool is used by somebody who's not a professional burglar. Okay, I just grossly simplified that, but you get the idea. So there's that notion out there. Well, okay, so here's the law about the notion. Is it a strong counter analysis? Is this a big one? What do you guys think? Was it a good was it a good counter argument? Does it give us a run for our money?
Are you meaning that from the memorandum?
Yes, in our memo, was our burglar's tool counter analysis any good? Or
Mhm. I don't think it would have made a difference.
right, I don't think it would either. I mean, I think you could, and I don't think it would have changed the outcome. However, it's there. It's on a certain level, it's compelling because we do have somebody who appears not to be a real burglar. We got this kid who doesn't appear to have a criminal background, didn't appear to set out with an idea that he was going to steal a xylophone. I mean, he plays the xylophone. Let's just start from there. And then we had facts in our fact pattern that told us that he wasn't even really looking to burgle when he entered, right? He was just like, oh, let me just try this out and see if I could open. That's what our facts are. Whether we believe it or not is neither here nor there. That's for a jury, but that's what our facts are. And we had some that said this kid doesn't have a criminal history, and his idea with inserting his card was just for kicks, just for fun to see if it would work. And so when we talk about we want to talk about that when we analyze this and say, on our facts, this idea might get some traction, right? Even though he bent it, he altered it, he used it to get in. Given this policy idea that's out there, that if you're not making this first degree burglary is done because this is the kind of thing that a professional burglar does. That's why it gets kicked up to first degree. But here we've got a kid who does not seem to be a hardcore burglar, doesn't seem to have any burgling experience. And maybe this is an argument why he shouldn't be found to have made a burglar's tool, because he's not really a burglar in the professional sense. And so we would want to explain those facts, tell our reader those facts in our counter analysis in the A part of our CREAC. But then we do have to circle back, because we've got to bring the train back around to that conclusion we already wrote, unless we've changed our own mind in the process, which happens on occasion. You can sell yourself on a new idea and have to rewrite the whole thing. But let's say you go, okay, that's great, but the fact remains that the winning argument is probably that this is going to be a burglar's tool. So we have to write our way back to that. We have to tell our reader, okay, here's the argument. He's just fooling around. He's a kid. He's not, doesn't appear to be a criminal. So this doesn't seem like the kind of person we would want to have charged with first degree burglary under this analysis. However, the fact remains the way he used it satisfies both prongs of that burglar's test, modified it, used it to facilitate entry, and therefore I'm going to return to my original conclusion. It's still likely that it's going to be found to be a burglar's tool. If you are getting tangled up trying to write it, or you're using facts in your analysis that aren't relevant, here's where we start to want to put others. The entirety of this counter analysis is based on that policy statement. That's all we were asked to do. So you want to use the facts that are relevant to that. Looked like he was just having fun. He didn't seem to be a burglar of any professional ilk. Therefore, that's all. It's small. It should be pretty small because it only implicates a very small part of our fact pattern. And it doesn't, there's not a lot of room for it to get a lot of traction. So I would raise it, get rid of it pretty quickly, and come back to my conclusion. What a lot of people wanted to do was bring in a whole, well, he didn't spend enough time, because it's true, but that's a different counter analysis. The one about, well, he didn't spend as much time on it as these other burglars, as our whittler and our non-whittler. He's somewhere between the 45 minutes of whittling a fence post and the no whittling. He's somewhere in between those, seems to be much closer to the not whittling, and that's fine. Those are important facts. That's a different counter analysis than we were asked to do. So I highlight it only because if you want to do that, I really don't think my meeting should end in 10 minutes. We'll see what happens. Okay, so that was that. I'm going to share that with you. These sites here refer you back to our to some tools that would be helpful probably to have a look at in our book if you need a refresher kind of on those concepts. So coming to Stewart, here you were given the viable counter analysis you were supposed to look at. It does not mean that the other counter analysis about where does this fall between 0 minutes and 45 minutes of whittling, a viable counter argument. Absolutely, you could make it. It's based on facts, not so much on law, right? And that's why this table in particular is quite helpful. But for our purposes, you were specifically asked to address this notion. The legislature may have assumed that altering tools in advance reveals a greater commitment, deserving a correspondingly more severe punishment. First, so down here, the facts we're going to talk about, we've identified the only one. We explain the law behind it. We apply that law, the policy, to these facts, and we have some facts. He tried it for fun. He just happened to be walking by. He didn't have a plan to break in. Kind of seems like he wouldn't be the kind of guy the legislature meant to pop for first degree. And so that's possible, but we might make it. However, he still used a bent card to open it and it fits within the definition, so it's not strong. There we are returning to our initial conclusion, bringing our person back, our reader. Therefore, and we go right back. It could be as small as this. Is it easy to make it short and fast? Of course not. It's much easier to write more. And frankly, it's the way I write. And then I go back and I edit down because each time I look at it, I see it with a new critical eye and I go, okay, how could I tighten this up? Are there extra facts in here? Is there extraneous language I can whittle out and tighten up? But that wasn't your goal with the week 5 assignment. Your week 5 assignment was literally take a crack at this and see how it feels and see what feels hard about it and see what seems easy about it. And you guys nailed that. I mean, to a person, you nailed it. So I felt great. Just so you know, I felt great about what you submitted for that assignment. We weren't shooting for perfection. Okay, so that's the end of my blathering. What have you guys, why don't you tell me what you've got on your plates, hearts, and minds?
I had a question. So when you're talking about the counter analysis, then it's not even so much the illicit or making it in advance for an illicit argument that you're focusing on. It's what we would consider a professional burglar or what the because there
Well,
isn't
it's
really a
what the court,
description of
well, we
the
pay,
court is saying a
it's a legal
professional.
argument in the sense that we pulled it from case law.
Yeah,
It's not the holding.
yeah.
It's the part of the reasoning, which is why we look at reasoning. So we found something we thought, ooh, that could be something that could help us out. Sadly, we don't have a court holding that says, even if the holding that would be money would be where you've got an adapted item that's used to facilitate entry, it courts are not going to conclude that a first degree burglary conviction is warranted if we have someone who has no criminal history and no there's no evidence supporting the idea that they had any kind of criminal intent at the time they made it, that they were just joshing when they used their adapted item to facilitate entry. If we had that, we'd be in great shape. And that would be a winning counter argument on our facts. But we don't have quite that. We just have some ruminating by a court that this is probably what the legislature meant. And
So we have the ability, I guess you're saying, to interpret what the court might have meant when they said professional
well, the
burglar.
court actually said it here. The court actually said the quoted part that you were given is actually a quote. And the court said, the court was ruminating, not us. The court said, in quote, we put in quotes, the legislature may have assumed that altering tools or implements in advance of a burglary reveals a greater commitment to the illicit undertaking, deserving of correspondingly more severe punishment.
And I got that part. I guess I'm struggling with I'm getting stuck on in advance. He bent the card in advance. So that shows, so I think that's where I'm struggling of how does that support your counter argument? It seems like the counter argument is more so based on what we consider to be a
The counter
professional
argument
burglar.
is the court, a court on
Yeah.
this exact same topic has reasoned that potentially there might be an underlying policy
Mhm.
argument in support of not convicted, not that it matters when or how it was, but even if it was altered, but there are going to be some cases in which we don't want to punish someone as a professional burglar. There are going to be some cases.
No, I hear that. I guess, yeah.
And so we have to explore that. We've got a client who, for all we can tell in this case, has a stone cold loser under the law as it's applied. This is a loser. Our job is to see what else is there. Maybe you wouldn't even spot it. Fine. But his defense lawyer will, right? Another defense lawyer will. Somebody who's happy to take his money, or whomever. Probably the public defender is more likely to identify it because he's represented a ton of these. But somebody's going to identify it, and so we just want to be mindful that it's out there because it could be compelling. Is it a loser? Probably, yeah. But is it worth raising? Yes, because there is something there. It's a maybe. It's a maybe. Some counter arguments are going to be much closer. This is not one of them.
Yeah, I guess I'm getting stuck on it seems like the basis for the counter argument and the policies around professional burglar and punishing them and the definition of what they used. He seems
Yeah,
to still
that's
meet the in advance
so
piece.
I would say
So just get,
don't back
yeah,
up and read the whole section from which we pulled that, right? The whole section. Don't fixate on the one sentence. Read the whole section.
yeah,
And what we're talking about, what we're citing to is this reasoning by this court that that the legislature really only meant to punish professional burglars.
that I agree with. I think that's where I was getting
So,
lost
but
is,
that's there in the case law. We didn't
yeah,
make that up. We didn't write it. That's not us. It's a legal argument because a court has ruminated on it and that got published. That makes it a legal argument. Does that help more?
yeah, I think we're saying the same thing in different ways, maybe. But
Okay.
what I'm
Okay.
gathering is he doesn't meet what we would potentially think of as a professional burglar, and we need to bring that argument up to light.
Yes, and only because we have something in a case that says that.
Yes.
You and me, if you and I were just ruminating in our bunny slippers and thinking, you know what? I don't think they meant to make this first degree burglary when it's a kid like Stewart, even though we technically meet it. That's not enough.
Hmm.
A court has considered that and published it as part of its reasoning. Now we can hook on to that. Or if we did we did the research into the legislative history and found the hearing transcripts where the legislators were debating and explaining the reasoning behind the language in the statute, we could cite to that and we could make our argument. But there has to be a legal basis. There has to be some legal authority on which we're basing that, not just our sense. Does that make sense? I
Yeah.
hope that makes sense. Okay, Rosalind,
Rosalind, thank you.
Rosalind, you've had your hand up, so go ahead.
Yeah, so I just wanted to confirm, like, I think where I was getting stuck is like Freddie said, like this was just like a giant mountain and I didn't know where to start chipping, right?
Yeah,
So like I think you kind of answered it while you were talking with Natalie, but are we supposed to like when we're figuring out the counter argument, we're looking at the facts first and then moving towards the case, or
well,
I
it's
don't.
part of why, it's a good question. First of all, I don't think there's an answer. I don't think there's a crystal clear answer, but what I do want to really recommend that you do, because I find it really helpful, is that I mentioned on that prior slide,